representative would depose, would on oath relate the work of his company to the documents as filed, and therefore I would respectfully suggest that no harm is caused by that process being engaged in. Even if we were to agree, well, we will not have any objections anyway, so that itself would be an expression of the consent of the parties. But if a representative of the company does tender them, then I think they become part of the record based on sworn testimony of that representative, and that would respectfully be the advantage of that process.
Well, you see, if a matter goes in by consent, there's no detraction about the fact that it hasn't come in through oath. The decree talks about things on oath, but I think it's well established that things can go in by consent. In that case, you don't need the root of the witness box. But if you think that there is some special advantage to it, we can do that. I thought that.
My lords, I think I heard you say that they would later be cross-examined on it.
Well, if the parties so desire. I mean, the reception of the document and cross-examination on it, there are two different things. It doesn't mean that if it goes in by consent, cross-examination cannot go in. It only dispenses of the formal procedure of the man coming to be sworn and tender. But if you want it that way, you can do it. But I'm quite convinced that no matter the regime of the law of evidence that a country uses, parties can agree to facts or put in documents by consent. And once that is done, the witness box is not necessary. But if you want cross-examination, a man can be called cross-examined.
Very well.
Well, anyway, the registrar called me this morning on the issue, and I said, well, we'll discuss it. But I don't know if your representative is here. It doesn't matter. Are they here?
My lord.
All right. Okay. We're trying to treat you gingerly because the service you've rendered is unprecedented, and we didn't want to vex you further beyond the sacrifice you've made. But once you are honorably here, I think you can tender the report.
You don't have one. You don't have a set. You have to let it report. You have to give me mine.
The one?
The other.
Please, before you give evidence, you have to swear by one of these religions. We have the Bible, the cross, the Quran. On the other hand, you can affirm in a manner that binds on your conscience. Which of these would you like to use?
I will use the Bible.
Please say after me.
I,
Your full name, sir.
Ni Amano Dodu,
Swear by the Almighty God.
swear by the Almighty God
That the evidence
that the evidence
I shall give
before this court
shall be the truth, the whole truth, nothing but the truth.
Nothing but the truth.
So help me God.
So help me God.
Lord,
Thank you.
SOB in English. Please take a seat. You address the names, my Lord.
I guess you shall guide me because I haven't intended it. Okay, thank you then.
Ask him his full name. Yeah.
Your full name, sir.
My name is Ni Amano Dodu.
Where do you work?
My Lord, I work with KPMG. I'll clarify who I am. But let me know when. I am a partner with the firm and head the audit practice.
Pardon?
I head the audit practice.
And you live where?
I live off the Spintex Road in Maryville Estates. Unfortunately, it's not a well-numbered development,
So you live at what estate?
in Maryville.
Maryville.
Homes. Maryville. Mariville.
Estates at Accra? Yeah, okay. Yes. You know why you are here?
Yes, my lords.
Why are you here?
Well, I guess to present our report to the court, my lords.
Yeah, report concerning what? The fight at Maryville Estates?
Yeah. It concerns the petition by the petitioners in the case. To present.
Mr. Dodo,
Yes.
you can just say you were appointed by the court. Your firm was appointed by the court to do this exercise. You have completed the exercise. He is an
Please pardon me, because this is the first time I've actually said this, but I guess I shall be guided accordingly. So, my lords, our firm was appointed a referee in this matter. We have completed the tasks under the court order, and we are here to present the report, the completed report.
Do you have the report before you?
Yes, my lords, I do.
Yes, can you describe it briefly? What it consists of?
Okay, my lords, our report is made up of the main body of the report itself and accompanying appendices. They are contained in a 5-volume document. 15 copies of which were delivered to the registrar for onward submission to all the parties.
Yes, so where is the report?
I have them here, my lords.
Yes.
That's it for the benefit of all.
Yes. You say, what do you want to do with it?
I'd like to tender them in evidence.
That's
Thank
right.
you. Please bear along with me because, it's the first time I'm...
Yeah. You've done well, because you were using the administrative term of presenting, but you've modified it correctly. Yes. Yes. So, any objection? This is tender.
No objection.
No objection, madam.
No objection, my lord.
No objection.
Yes. So this is.
My forehead. Okay.
This document is accepted and marked 4th Exhibit 1, 1A, 1B, 1C, and 1D.
Your air conditions here are not very effective.
Well, I suppose for the meantime, this should be sufficient for him, isn't it? Yes. So, well, you are temporarily discharged with the gratitude of the entire court. You have our provisional gratitude. We will give you the final and full gratitude, the completion of. So you may be recalled if the parties so. If they don't, then that's fine.
Okay.
Thank you. So,
thank you, my lord.
Discharged for the meantime. Yes.
Yeah, thank you. I shall convey the appreciation accordingly and will present myself when notified.
Fine.
Thank you.
That's good. That's good.
Would it be appropriate for us, the bar, to indicate our appreciation for the work of the referee, especially the basis on which they agreed to do the work without any remuneration? This has been a bit of a longer drawn-out process than perhaps even initially anticipated, and we would like to convey our gratitude for the work of the referees.
Yeah. Okay.
My lord, that's a shared sentiment.
Lords, we share fully in the sentiments expressed, my lords.
My lords, we also share fully in the sentiments expressed by counsel for third respondent.
Rare moment of agreement between all counsel in this court.
Mr. Addison, have you completed your cross-examination, save and accept matters related to the report of KPMG on the pink sheets?
My lord, I have not completed the cross-examination, and the way we want to proceed, we need to deal with some of these pink sheets before we can move on.
Okay. Okay. Yeah. So how long would you need to study?
Respectfully, if we get 2 clear days, that will be sufficient for us.
Well, you've had the application. What's your reaction to it?
I've seen that you have a motion fixed for tomorrow.
Yes, my lord.
So is your 2 clear days anticipating?
I was actually going to make an application for that also to be adjourned to the same date as
My lords, we all had the draft report, and we flipped through. There isn't much that has really changed. 2 days to study this, I think, is a bit on the high side. Without imposing, I thought a day to find out what comments were made, whether they'd be incorporated in the report, should be sufficient. In fact, I didn't get the impression they were going to look at the data, especially just the introductory part. So we would respectfully suggest that perhaps we return tomorrow to continue with some work.
My lords, we all looked at the draft report and had a meeting on Friday on it. So I would have also thought that maybe the rest of today would have been sufficient for the report to be studied further, and so that tomorrow the motion that has been fixed can be moved, and then the work of the court can continue. That would be my respectful submission, my lords.
I would respectfully associate myself with these last submissions, especially in respect of the motion that is currently being filed before this court. My lords, that motion has been fixed for tomorrow. There's absolutely no reason given for this request for that motion to be adjourned by a further few days. That motion is independent of the KPMG report. It's a motion to produce certain documents. And my lords, at the time that you adjourned for this extended period, it was contemplated that the respondents would complete their cross-examination after the report has been filed. If they want time to study the report, I think, my lords, it should be a reasonable time in the light of all the circumstances. We have all had this draft report since last week, I believe Wednesday or so, and the Wednesday or Thursday, my memory is not clear on that. But we have had it over the whole weekend. We have also, in fact, confirmed that not much has changed except perhaps some additional information provided in a certain summary form as discussed at the meeting on Friday. So respectfully, there cannot be a justification either for seeking 2 clear days as has been requested. We have already had a fairly extended break, and my lords, I believe that justice is not well served in this case by this constant process of extending the time to resolve these matters.
My lords, the draft we received was in 4 volumes. This morning we have been served with the final report, which is 5 volumes. Also, we made substantial comments on the draft. That is why we need this time to cross-check if these comments have been incorporated in the final report. I can understand why the second or third respondent need very little time, because they made very little comments on the draft report. But we had substantial issues that we raised on the draft report. And we need time to go through this to satisfy ourselves that these things have been incorporated in it. That is why we are asking for the time. We will be the last people to seek to delay this matter. But we think that it is important that we get sufficient time to go through the report. And since without going through the report, we cannot go on with our cross-examination, we thought there would be no point coming to court tomorrow only to hear the application. That is why we are asking that it be adjourned to the date on which we will take the report.
Well, with the greatest respect, the last time this case was adjourned, it was to enable counsel to determine whether they would use a certain category of exhibits to cross-examine. That was the only reason why that cross-examination was adjourned. Now, I am beginning to think as if the adjournment is being sought in order to study the report for purposes of cross-examining KPMG. But that was not the reason why adjournment was granted for the completion of cross-examination of Dr. Afari-Jan. Some exhibits were lined up to be used. And then, of course, we challenged the use of those exhibits. So the point then was that then let's get the report and let's find out whether those exhibits are part of the report so they can use it to cross-examine. So that is all that is required to be done for purposes of completing the cross-examination of Afari-Jan. Any other cross-examination, either directed to the report, of course, if you ask for an extra day, that can be understood. But for the limited purposes for which adjournment was granted, for the completion of Dr. Afari-Jan's testimony. I think 2 days is 1 day too many. Yes. Yes, my lord. Yes, my lord. No, my lord, I didn't understand it that way.
But that is essentially what. Any witness who tenders a document, if there are any questions to be asked, it has to be done for the completion of the tender of the document. If there are no questions to be asked, then that's all. Because in any case, the comments that were made, that you claim, all of you claim to have made, if they are not embodied in the document, then they will have a problem with it.
Oh, my lord, there was no indication that they were going to accept our comments. They made it very clear that the final determination was theirs. And that once they looked at those as comments, they were not necessarily going to incorporate them anyway. Anyway, I'll defer to your lordships on the time. I just thought that 2 days is just a bit too long for that exercise, that's all.
My lords, respectfully, Dr. Farijan's testimony in cross-examination was stood down in order for this very narrow issue in respect of the documents that they sought to show him as exhibits in this case. That was really the occasion of the adjournment. Now, respectfully, what your lordship, Justice Bafuboni, just said suggests that there has to be cross-examination on the report before. But respectfully, cross-examination on the report need not wait as far as cross-examination of Dr. Farijan is concerned, because in the same way as Dr. Farijan was stood down as a witness to enable the completion and tendering of the report, the witness was stood down. That is my understanding. The witness was stood down a short while ago. There was no indication of when exactly he would be recalled, and the court indicated that at the time he would be needed, if at all, he would be called back. But that process, respectfully, need not come before the tendering, before the completion of the cross-examination of Dr. Farijan, which is in progress at the moment, because otherwise we lose the essence, respectfully, of the witness being stood down temporarily, just in respect of the exhibits that had been put forward to him. And the authenticity of those exhibits was essentially the reason why the court had the break.
But, Mr. Chikata, I think that the procedure normally is that when the report is tendered, if there is any cross-examination, it follows. You can't interpose another witness evidence with the evidence of the man who was already in the box. So, for instance, today, if they were mindful of going on, the cross-examination should have followed immediately after the report had been tendered. So the procedure is that you ask questions on the report as it is tendered.
I believe the essence of the long adjournment was to enable Mr. Addison to complete the cross-examination of Dr. Farijan, because we had reached a stage where almost all the respondents, almost all of you, claimed that some of the pink sheets that were being pulled out had not been supplied to you by the petitioners.
That is so, my lord.
So it was our understanding that with the completion of the referee's report, the KPMG report, which we now have as Exhibit CE1A 1 to 1D, I believe that then he can conclude his cross-examination of the pink sheets, provided those pink sheets have been identified in the exhibit as having been supplied. If they have been identified as having been supplied, then he will go ahead with the cross-examination. But before he can go ahead, we must fully discharge Ni Amano Dodu as CE, as court witness number 1. Then we can continue with Dr. Kojo Afarijan. I think that is a neater way of going about the procedure, Mr. Chikata.
As your lordships please, all I was indicating was that the person in the witness box is actually Dr. Afarijan. Dr. Afarijan is the person in the witness box. He was actually stood down. And in respect of this report, the aspect that concerns identifying, if they can be identified, the exhibits is a very limited part of this report. That is an extremely limited part of this report. But as your lordships please.
Order in court.
So, Mr. Addison, counsel for the petition, Mr. Addison, these two clear days, what does it mean?
I'm sorry?
2 clear days.
What does it mean? We'll come back on Thursday.
Meaning Tuesday and Wednesday.
That is so, man.
That is clear days.
That is so.
Then you might as well come next week.
I'm sorry, man.
Then we might as well come next week to start a whole week. Because I believe we are...
My Lord, if we clear this on Thursday, then on Monday we can go on with the cross-examination.
Oh, but I guess 2 days is just too much, I think. What about moving your motion tomorrow? What's this about? Adjourning the case to tomorrow? This motion to tomorrow.
So that we can take the motion as well on Thursday.
Why? How dependent is the motion on the...
Well, to save us the trouble of coming tomorrow just for the motion.
Oh.
Also request that the referees give us an electronic copy of this thing.
My lords, perhaps to assist us in a quick examination of the report, I don't know if the referees could be requested to provide us with soft copies of the report.
I will pay for it.
We will pay for it because that will assist us.
My lord. No. We agreed on this. My lord, during the meeting, it was part of the terms of engagement. The referee was quite categorical. They will keep one soft copy and give everybody a hard copy. And those were the terms of engagement. And there's a reason for that.
That is before the What is this? The rules.
My lords, I mean, we need the electronic copy. If they don't need it, that is fine. All we are asking for is the electronic copy of this report. That's all. We'll pay for it if there is a cost. They don't have to ask for it if they don't need it. That is all. And I'm sure it can easily be provided by the referee. That is all we're asking. And the rules provide for it anyway.
They said that single one will be kept under lock and key, so that if there's any reproduction, it's got to be from that one and that one alone. And they are very clear. And I remember that, I don't know why the fuss is being made. We all agreed, it was part of the rules of engagement, that only one soft copy will be provided and kept under lock and key. Everybody else gets a hard copy. It's too late to change the rules now, and we object to it.
The hard copy, the one that you intend keeping under lock and key, can't it be kept?
My lord, it's because they don't want information adulterated. It's not because of anything.
Well, you can keep yours.
My lord, not mine. The referees were very clear.
The one to be kept under lock and key can always be kept under lock and key.
My lord.
So that if there is to be any reproduction, as you may be thinking of, you can still fall on the one under lock and key.
No, my lord. We didn't set the rules. Very respectfully, we didn't set the rules. We sat down with the referees, and the referees were very clear that they would not provide anybody with soft copies. My lord,
leave that issue to the referee for him to say he can't provide it.
Oh, my lord, yes. my lord, with the greatest respect, your lordships have taken a position of not getting into this exercise. And I think that where the parties sat down and took a decision, and at this time, it's a bit, with the greatest respect, it's intruding into that decision because it was by consent and by the referee's own listing that we agreed to do that. And
from what I'm saying, please let the referee tell the court. But this is the agreement on which I proceeded to work, so I can't provide it. That's all.
My lord, we all agreed. We all agreed to that procedure, so that even the daily data that was provided was never provided in soft copy. They were provided in hard copy and signed off. Those were the rules by which we started. If your lordships want soft copy, I believe the registry that can be discussed with the registrar. But for the parties, we were very clear about what the rules were. We're very clear, my lord. And there are issues about soft copies of documents flying about that are not part of exhibit, and I think we don't want to confuse issues with soft copies, running around the place in a matter as serious as this. We've gone too far. We've gone really too far.
Well, these documents are now court documents, and all we are asking for is a copy of these documents in the soft form. I cannot see why anybody would take an objection to this. It sounds very strange to us. But the thing has been exited, the documents are there. We need the soft copy to facilitate our going through the report. And an objection is being taken to this. It's very strange.
Council should not make it sound as if I'm saying something strange. Those were the rules of engagement. So I am not changing the rules. I shouldn't be made to appear as if I'm being difficult. Those were the rules of engagement.
My lord, it has always been my understanding that we would receive a hard copy. That's what we have received, and anyone who needs copies can photocopy this, my Lord. There has been no agreement on any soft copy, my Lord.
My Lords, respectfully, there is good reason. My Lords, respectfully, there is good reason for the agreement that was reached between all the parties and the referee. There is very good reason for it. My Lords, we do not wish to cast any aspersions on anybody, but the dangers of reproduction in a manner that is not authorized are real. We have to call a spade a spade. There have already been issues in this court where even hard copies are transmogrified from a certain number of boxes to another number of boxes. And so, my Lords, we do have to take seriously this agreement between the parties. It is indeed, as I indicated, it's rare that there is agreement between the parties, but this is one of the issues on which there was agreement, and with the greatest respect for your Lordships to set aside that agreement without a proper application with justifiable grounds and with the consent of the referee who did the work they did on the basis of that agreement. They did the work on the basis of that agreement. And my Lords, there's been discussion also about the way they expressed disclaimers. They were very concerned about the reproduction and the use of the report for various purposes outside this court's orders. So, my Lords, at this stage, respectfully, I mean, your Lordship's issue about what difference it will make and so on, as I said, we do not wish to cast undue aspersions, but the reality is that we all agreed in a considered manner to this process in order not to compromise the integrity of the report. This was also very much at the instance of the referee, and it lies ill in the mouths of the petitioners at this stage just to jump up and say that they find it strange that we should be objecting to something which they had agreed to do the opposite of. So if anything is strange, it is their suddenly springing up and coming up with this idea of a soft copy. Of course, I mean, there are pros and cons of soft copies, but all that was discussed and considered and an agreement reached. If your Lordships are in doubt about an agreement, that's another matter. But petitioners are not disputing that there was an agreement, and that respectfully should be the end of the matter.
My Lord, the respondents kept saying that there was agreement. They never stated what really the agreement was. Now, at the beginning of this whole process, it was agreed that soft copies of printouts will not be given. That was the agreement. So we're being given printouts, daily printouts of the work that had been done. Now the work has been concluded, a final report has been submitted to the court. And all we are asking is for a soft copy of this report. How can we be barred on the grounds that before the start of this project, we all agreed that soft copies of printouts would not be given? Does that bar us from asking for a soft copy of the final report? The law even provides for that. And I am just amazed about this opposition. I'm saying if they do not need a soft copy, we need it for our analysis. And I do not see in what way it will detract from the exhibits that have been filed in this court this morning. Nothing will be taken away from the exhibits that are in court this morning. We are going to use it for our own purposes, and we think that it will speed up the process for us rather than pouring through these hard copies. That is all. They might not need it, but we need it.
My Lord, the agreement was not for just daily generated copies. The agreement was that final copies will be in hard form and that there will be only one soft copy which will be kept and that it will not be reproduced. That was the agreement. That was the agreement. The chorus is getting too loud at the other side.
The referee could you come briefly? Yeah, remind him, yes. Yes, I think you followed this rumpus over a soft copy of your final report. And the tussle about the nature of the agreement reached over it. One side is saying that the agreement was at the initial stages. It was limited to the initial stages, but not in respect of the final report. Another side is saying that the agreement about soft copy was also reached. Was reached in respect of the final report. So, can you clarify the position to the court?
Right, my lords. Ordinarily, we do not give soft copies of work papers, reports, out to the parties for which we would do any engagement. And that's from a risk management perspective, so that, those documents which would bear our names will not be subject to any changes that may be attributable to the report in its original form. So that was the basis on which we reached that agreement. Again, if you go through the contents of the report, you will clearly see some disclaimers and limitations which deal with restrictions on extracts from the report, which will have to be subject to, our prior approvals. The reason for that is to avoid situations where things are taken out of context.
Well, it appears I follow, but could you be much clearer? As I said, the distinction was drawn about this soft copy furnishing. Whether it was at the initial stages as the work was progressing, or it also covered the final report. What was agreed on it as regards the question of supply of soft copies of the final report?
Yeah, we categorically mentioned that we will not be in a position to provide any of the parties with soft copies. However, if any of the parties, would want some understanding, how results or, results of procedures that were carried out were reached, we will be open to that. I mean, we can actually take them through the processes that we followed, the tools that were used to reach those conclusions. But in terms of handing over the soft copy, basically from a risk management perspective, we do not, as a firm, hand over soft copies.
Yeah. All right.
I'm wondering, from what the witness is saying, it's as if they have now adopted the report as theirs, and it is no more a public document, that they are imposing their rules on us. A matter affecting the presidency.
Look,
it is not their document.
No, look, what we are ascertaining is the nature of the agreement reached over the supply of soft copies of the final report. I think that's what he has clarified.
Okay, well, there was no agreement covering the final report.
Okay.
And we did not understand that this report belongs to KPMG.
My lords, if I may come in here, I mean, if we ordinarily carry out an audit, what he's referring to will be the equivalent of what we call work papers. Work papers would ordinarily not be handed over to the parties that commissioned us to do the assignment. It is the final report, which would either be in the form of financial statements, management reports, and highlights memo, if any, that will be delivered, which will be the equivalent of the reports that have been submitted. As I said, if for any reason there's a need to clearly understand how the results were reached, we could, go through that process with them. It should not be a problem at all. But handing over the soft copy, basically from a risk management perspective, we have it as a policy not to send that out to any party that contracts us to do any work.
Yeah, following that, I probably you said, but we not so much on your policy internal, but was there a definite agreement reached by the parties that no soft copies of the final report will be issued to any party?
Yes, we did categorically state so.
Okay.
No agreement on the final report. There was no such agreement on the final report. So please check.
Well, okay. Well, you see, okay. I'm sorry. I can understand if you say no such agreement on the final report, but we did not discuss it within the context of drafts, final, or anything. It was just that soft copies will not be made available. So specifically relating to final report, yes, we did not make specific reference to a final report, but we did speak about soft copies and limitations on their distribution. But as I suggested, I mean, if you want to go through the processes and procedures, we can. Thank you, my lords.
position. In view of the testimony of Ni Amadodu, CW1, that's court witness 1, on the issue of supply of copies of the report in soft form, we refuse the application for the same by the petitioners. By 7-2 majority, Eni Abua and Gbedegwe JJSC dissenting, case is adjourned together with the petitioner's motion to produce documents to 26th June 2013 for continuation.
But they should have let it be. So they wanted you to write them down, that they are not agreeing to the adjournment.
When we say order in court, we mean what we say. The court should not be turned into a stock exchange a forum. Now, we've been giving warnings without achieving results. We did not want to take any drastic action, but it is our duty to uphold the authority of the state. We have no power to let down the authority of the state. The power is not ours. So we do not want to surrender the authority of the state to any individual or group of people. The authority of the state is paramount. We have drawn attention to unacceptable statements made by counsel and the media, and giving indication that we will not accept that situation. But it seems not to be yielding any fruits. Accordingly, we have taken the position that any person, be in the media or not, who crosses the final touch line of proper coverage and reportage on our court proceedings will be met with the appropriate response from this court. As I said, is to uphold the authority of the state. Because when the authority of the state is submerged to the authority of individuals, then the state ceases to exist, and anarchy and overmighty subjects then reign. We cannot accept that. Let me give examples. Last Thursday, I think that was Friday or Saturday, there was a publication in the Daily Guide giving a certain twist to the discovery of, alleged discovery of my pink sheets. I have directed the pink sheets that were lost have been found. I have directed that the KPMG should come for them. When they come for them, it's going to balance out certain things. I mean, this type of thing. And another matter, concerning, yes, the final report which has been tendered. I was informed by my colleagues that the entire report was already in the press before even we received it. So let it be known that much as we do not want to visit any unpleasantness on anybody, it is our bounden duty to uphold the authority of the state in its judicial sector. And therefore, this acquisition of uncontrolled power to do what people want in relation to twists and spins on our proceedings will be halted through the sanctions of the court. We think we are clear. Subject to this, the case is adjourned to Wednesday, as aforesaid, for continuation. Yes, please.
All rise.
Thank you.